Hi, I'm Robin Nitchie with Robin Law 2020. I'm an estate planner and I want to talk to you about revising your old estate plan. If you have an old estate plan that you've been thinking it's okay and you can hang in there with it, I would love to talk to you about some of the reasons why it might be a good idea to go ahead and have it revised. I have an old estate plan. That's okay, right? The short answer to this common question is probably not. Estate planning is not a one and done task. It's an ongoing process. In general, as your life changes, so should your estate plan. Accordingly, it's important to review your estate plan periodically and revise it as needed to ensure that it lines up with your current wishes and continues to serve your estate planning goals. How often should you review your estate plan? You should review your estate plan at regular intervals. Depending on your age, this might mean every 3 to 5 years, or perhaps every milestone birthday. As part of these regular reviews, think about your current estate plan and ask, who benefits? Is everyone you want to benefit accounted for? Are individuals named in your estate plan that you no longer want to share in your estate? Are all of your assets and property included in your estate plan? Who is designated as your financial agent? Your healthcare proxy, the guardian for your children? Are you still comfortable with all of these designations? Do you still trust these individuals? Depending on the answer to these questions, you may want to revise your estate plan. In addition to these regular reviews, you should review your estate plan in conjunction with significant life events, such as a change in your marital status, your family status, or your employment status, a change in your health or the health of your spouse or a family member, a change in your financial situation or your long-term financial goals, a change of residence if you move to another state, a change in circumstance involving the person named as a guardian for your minor children, or a change in circumstances involving the person designated as your agent for financial affairs or healthcare decisions, should you become incapacitated. Any one of these life events is likely to trigger a need to revise your estate plan. So how do you go about doing that? There are specific procedures and best practices for making changes to each of those components of your estate plan. What works best for you will depend in part on your specific circumstances, but there are a handful of ground rules that apply across the board. Ground rules. Treat your original estate planning documents with great care. Do not unstaple the originals to make copies or to remove or add pages. Never make handwritten changes to any of your estate planning documents. Handwritten changes are likely to be ineffective, and worse, they may even void the entire document. The second one is to review your beneficiary designations. This step is often overlooked, but it's important to review your beneficiary designations as part of your estate planning review. Make sure that these designations are consistent with the rest of your estate plan and do not cause adverse consequences for you or your beneficiaries. 3, don't put it off. If you know you need to revise one or more components of your estate plan, do it as soon as possible. Delay opens the door to unexpected events that might frustrate your intentions. 4, reach out to an estate planning attorney. There are specific rules that must be followed in drafting and executing an estate plan. Those same rules apply to revising your estate plan, and you have to follow the rules. The legal and practical consequences of making a mistake can sow discord and confusion and undermine all your careful planning and good intentions. There's too much at stake to risk a do-it-yourself revision. If changes in your life have made it necessary to change your estate planning documents, seek the advice of an experienced estate planning attorney. If you have questions about reviewing or revising your estate plan or estate planning generally, we have answers. Call us at 512-581-2938 to schedule a free consultation.